Mr. Rosen.
Morning, my lord. My lords, I'm going to deal with the submissions made by my learned friend insofar as I've captured them and consider that I need to respond to them in the order in which he made them. So we start with what I would describe as a reasons challenge. An argument which I think, with respect, Mr. Singh advanced with diminished enthusiasm as it went along. And one can readily see why that might have been. His central thesis appeared to be that the trial judge had not dealt with the different representations separately, but had dealt with them together. Of course, the answer to that, which I think fell from my Lord Justice Nugee, was that given the answer that the learned judge had given, there was no point in dealing with them individually, because the answer would have been the same in each case. A suggestion to which I don't believe my learned friend had an answer. It was also suggested, I believe, by my learned friend, that at one point the judge had conflated the giving of representations with the question of reliance. And that was said to be the case, I believe, by reference to paragraph 87, the Kofi Annan reference. Well, also I'm going to come back to that. It's point 3 in my learned friend's substantive argument. But for now, could I just say that that is not correct? The learned judge was making a point on reliance, but making it clear in passing that he was well aware of the point being made about the case on representation by the claimants. Finally, I think the learned judge was criticised by reference to paragraphs 12 to 13 of the supplemental judgment for dealing only with the IPD. In order to understand why that is a bad point, perhaps it would be helpful to look at the supplementary judgment in the core bundle. My core bundle has just fallen apart, so if you bear with me for one moment. No, that's right. Sorry, my lords. So it is right that in paragraphs 12 and 13, the learned judge deals only with the IPD. But if you look back at paragraph 1 of that supplementary judgment, the learned judge is dealing there with ground 1. Ground 1 was inadequate reasons are given for the rejection of the claimant's case based on the defendant having made false written representations. This is particularly so in view of the court's finding that the documents presented at the 13th and 14th meeting included the IPD or extracts thereof. And, my lords, what I would say is that when the judge was addressing the question of the IPD, he was doing that in direct response to the ground of appeal which he was considering and rejecting. But while I'm there, your lordship should notice ground 2, on the basis of the evidence available, in particular the IPD, it was not reasonably open to the court to conclude that no written representations were made by the defendant at the April 2018 meeting. And as the learned judge points out in paragraph 14 of his supplemental judgment, that is to misunderstand his judgment. He said, my overall conclusion was not that there were no written representations made, but there was no actionable misrepresentations made, or intended, or understood in writing or orally. And what he says there is that that is a matter of assessment of written and oral evidence said to add up to that is preeminently a matter for the trial judge, and for that reason he refused permission to appeal. So, my lord, what is clear there is that, as appeared to be the case from paragraph 89 of his judgment, he wasn't saying that no representation was made in writing. He was or indeed orally, what he was saying was that what mattered was what was intended by the maker of the representation and what it was understood to mean by the recipient.
He never actually identifies what was intended or understood in terms, does he, or does he?
Well, my Lord, he certainly deals with the question of intention by reference to the vision that Mr. Modi had, and that it was all about his grandiose vision.
It was aspirational.
And aspiration. In terms of understanding, what he says is that the Margs, being intelligent people, experienced people in investment, would not have been taken in by anything that suggested anything further than that from Mr. Modi. So you're right. I don't think he says it in precise terms exactly what the Margs did understand, but in a sense he didn't need to do that, because all he needed to be able to deal with was what it was pleaded, and he did not accept the pleaded case.
Just picking up a point I raised with Mr. Singler.
Yes.
The judge, as you say, accepts the idea that the IPD in particular was no more than aspirational, and that ties in with the vision concept. On the other hand, the judge doesn't accept the merely illustrative concept. What is the difference?
Point two, and I'm going to come to, why don't I deal with it in the context in which it arose in my learned friend's submissions. There's a short answer and a very simple one, but perhaps I could deal with it in that order if your Lordship doesn't mind. It's interesting, of course, to note the rather more limited scope of the permission sought there by reference to what is now the subject matter of the appeal.
Mr. Mill, can I just ask you about paragraph 84 of the main judgment?
84. 1 second, my Lord.
It may be a slightly different point, but it does appear to be, when one reads the judgment as a whole, part of the reasoning of the trial judge on this issue. In the second half of paragraph 84, he's turning to a slightly different point from the vision or aspirational point, and it's more to do with the fact that this was an early meeting.
Yes.
He suggests that the meeting was obviously only the start of a more formal process.
Yes, my Lord, and it's quite clear what the learned judge had in mind there. If you read that together with paragraph 10 of the supplemental judgment,
Right.
where he says that the circumstances around the IPD were illuminating. The late night informal setting between people who knew each other socially, soon after a chance meeting with plenty of time, opportunity and contact afterwards for any relevant confirmation or further investigation. What use was made of the IPD or parts of it as a manifestly incomplete draft, alongside what oral explanations and answers to question might have been sought or given alongside it, was not fully and sufficiently clear from the evidence. Indeed, the information memorandum which started the formal process soon after did not mention the allegedly participating outside individuals. So I think, with respect, what the learned judge was there doing was setting part of the context in which the representations were said to have been made. And that includes the fact that it was, as it were, clearly an initial meeting rather than one that was intended to conclude anything. I don't know if that answers my Lord's question. Perhaps it doesn't.
No.
That's how I read it. Anyway.
Yes, well, it's interesting to see how you read it. Yes, thank you.
My Lords, I think finally on the reasons challenge, it was suggested that the learned judge failed to deal with all of the funding representations because he only dealt with 2 of the 5 individuals pleaded. And my Lords, I'm so sorry, my Lord, I'm just finding the reference. Yes, it's paragraph 78 of the judgment. And what my learned friend referred to yesterday was the end of that judgment, where he says, I'm not at all satisfied that he stated orally that Sheikh Nayan had committed 100 million Dr. Shinawatra 60 million is alleged in paragraph 21 of the particulars of claim. So just 2 points to make about that. Firstly, if your lordships were to pick up the unagreed bundle, T3, page 270. Bundle. Oh my goodness, falling across this morning. I'm so sorry. Jonathan. Thank you very much. Page 270, internal page 49. This is cross-examination of Mr. Marg on day 3. And my junior at line 22 says, so the funding representations amounted to 2 individuals promising to commit 160 million at some point in the future. Yes, yes, but not yet, crucially, yes. So those are the 2 people who are dealt with in the judgment in relation to that. And then he goes on, and this is the Mr. Marg going on, and 3 people saying that land will be made available for the project. That's the question. Yes. So far as land being made available for the project is concerned, if we go back to the judgment, paragraph 78, we see that that is in fact what the learned judge was dealing with in the first part of that paragraph. And so, my lords, I simply don't understand the point that my learned friend is making. The case being put at trial, certainly by Mr. Marg, is one that is addressed fully by the judge in his judgment. So, my lords, as I've already indicated this morning, the key point for my lords on this appeal is not what was said or written. It's what Mr. Modi intended by those words and how they were understood by the Margs, which takes us, of course, to paragraph 89 of the judgment and the central argument on this appeal that no reasonable judge could have concluded as there set out. Mr. Singh, in his submissions yesterday, asserted that this was one of those rarest of cases where a court could so conclude in relation to a trial judge findings of fact. In our respectful submission, that is manifestly not the case, applying the case law to which I referred the court yesterday. If there is anything about this case that is exceptional, it is that Lord Justice Arnold, for whom I have the greatest of respect, fell into error in concluding that this appeal had reasonable prospects of success. In my respectful submission, that was not the case, and it isn't the case today. Can I now turn to the 7 points that were made in support of this central argument? The first is that the judge found that Mr. Modi was confused as what was vision and what was reality, and that is a reference in the judgment to paragraph 83 and the first sentence of that paragraph. Of course, the confused account to which the learned judge is referring there was Mr. Modi as a witness at trial, not as a purveyor of information or vision at a meeting. The learned judge's observations about both parties' approach, which your lordships may find helpful, be reminded about, can be found at the beginning of the judgment, paragraph 7. and I think that my lords may have seen enough in the transcripts fully to understand and appreciate why the learned judge said what he said here. He said both sides made some extravagant claims of varying significance, as mentioned in my review below. Sorting the wheat from the chaff was not always made easy. I note at the outset, however, that both sides exhibited in their different ways some fluid meanings for terms such as commitment and advanced various other incongruously naive assertions. In my respectful submission, there is much to said by way of endorsement of that paragraph. Lords, what follows from paragraph 83 and the context in which the statement about the confused an account arises is set out in 83 through 86. And there is and can be no criticism of the contents of those paragraphs. And in particular, the judge was clearly entitled to reach the conclusions that he did in paragraph 86. I just invite your lordships just to remind themselves as to what that says. In those circumstances, my lord, I don't really understand where this point is said to go or where it does go. And unless I can help your lordships further on it, I propose to move on. To point two, for the benefit in particular of my Lord Justice Newey, the distinction between illustrative and vision. My lords, the distinction is, with respect, a simple one. The learned judge found that Mr. Modi knew most or all of those mentioned in paragraph 82 of his judgment. And so when he was presenting his vision, it was those people he wanted involved in iron care, not people of that ilk or like them. In that sense, they were not illustrative. In other words, just to be quite precise about it, it could have been the word illustrative, which derives in fact from the defence, in this case paragraph 21.
And we were told was not used by Mr. Modi in evidence.
In evidence, that appears to be correct. We have checked that this morning, my lords. And it does appear that the word, I mean, it was referred to in closing by my learned friend, it was referred to in pleading on behalf of Mr. Modi and a document signed by him. But you're quite right, it was not in fact in his evidence, neither in the witness statement nor in the cross-examination. But obviously, insofar as it was still being relied upon as a point, it was rejected by the judge, and he had to deal with it because it was in the defence and in the closing argument. But what is clear is that the word illustrative was intended to suggest that the named individuals were not specific individuals identified as targets specifically, but simply symptomatic or illustrative in that sense of the sorts of people who Mr. Modi wanted to say might want to get involved or might be approached. And that's the distinction. I don't know if that's sufficient or clear, but that's my understanding of the distinction between the two and why you can have a vision without it being illustrative and no inconsistency arises as a result. My lords, that takes me to the third point, which is the judge's treatment of the Kofi Annan message. I said I'd come back to that. It arises from paragraph 87 of the judgment, to which I invite the court to look. So there are 2 points in relation to that were being taken, one by each party. The claimants said that the text message supported their case, that Mr. Modi told them that Mr. Annan was signed up to be involved in iron care. In cross-examination and in closing submissions on behalf of Mr. Modi, a different point was made by my client, was that if Mr Modi had told them that Mr Anand was signed up to be centrally involved in iron care, and if they'd really based their decision to invest on that involvement, then it was odd that his death didn't even elicit a comment from them, and certainly didn't cause them to pause before committing their investment. He having died in August, that is to say some 3 months before the investment occurred. And the passage to which I can take, my lords, if it's helpful, but it's day 2, pages 98 and 99, in which that point was being put to Mrs Marg by Maloney Jr., is one in which the judge was involved. So, my lords, with that background, turning to paragraph 87, the learned judge is referring to both points. He's specifically dealing with it there in the context of our reliance point, but he makes it clear by what he says at the beginning of the paragraph that he has well in mind that this was a point of particular significance for the claimant in their case on what representations were being made. A striking reference. So, although there are 2 points being referred to in that paragraph, there's no conflation of the 2 points, no misunderstanding by the judge of the points that he has to consider on that.
Does he say why the Marg's argument about that was wrong?
Well, my lord, clearly he has taken it into account in his overall assessment as to what the Margs understood Mr Modi to be saying.
I mean, if one takes it in stages, when you judge what was said at the meeting, stage 1 is what a reasonable person would understand, but that perhaps doesn't really matter here. Stage 2 is what Mr Modi intended, stage 3 is what the Margs understood.
Yes.
We have Mr Modi saying after Mr Anand's death, I forget it, Mr Modi, a board member and trustee has died. Mr Anand, a board member and trustee has died. Why wasn't that strong evidence that Mr Modi had intended to state something to that effect at the meeting, and not merely put forward Mr Anand as something aspirational?
Well, my lord, I'm not saying that it wasn't evidence that was imposing. Indeed, that's why the judge refers to it as a striking reference. But that clearly the judge has taken all the factors. What's clear from that is that he had it in mind and clearly took it into account, but nonetheless concluded as he did on the totality of the evidence. Now, right it is that he doesn't specifically say why he didn't find that a sufficiently compelling argument. But he didn't need to, in my respectful submission. And you cannot say, based on that, that he wasn't entitled to reach the overall conclusion that he did. Lords, moving on, if I may, the 4th point is the boasts and puffs point by reference to paragraph 62 of the judgment. And it was suggested there was some inconsistency in the judge's reasoning and thinking, because you could only have a boast or a puff if the comment which was said to be a boast or a puff was said to be a statement of fact as opposed to something of future intention. I think it's important, against the background of that submission, to look at what the judge meant by puff. And he deals with that in transcript day 6. At page 29. and I should maybe get the context, start at the bottom of 28. This is more fundamental, isn't it? This is the difference between specific statements of fact and you look, given the passage of time and the fallibility of recollection, you look at the evidence, whether it's sufficient to prove that in a fraud case. And what we used to refer to as puff, you know, where the salesman makes grand general statements about capacity or future intentions and so on. So the only judgment he's referring to puff is actually referring to it in the context of Mr. Modi's vision. So there is, of course, no inconsistency within that aspect of the judgment. Next, we have the context of the meeting, and we, of course, accept that the context is crucial. I took, my lords, just now to paragraph 10 of the supplementary judgment, where the learned judge set out what he regarded as the relevant context. Should perhaps also in that context, in particular given the question from my Lord Justice Singh, refer to paragraph 78 of the judgment, where he refers, in the third line, to the meeting as being obviously a first preliminary meeting. Well, what does it amount to? These points are all points that were made at trial, and they failed to persuade the judge as being more significant than the ones that he referred to. My learned friend just wants a second bite at the cherry. No suggestion that the learned judge didn't have the points in mind.
Just thinking about the context for a moment, as you say, late night, relatively informal meeting, but you are presented with something called, whatever it is, investors' pitch deck. That's a pre-prepared document. It's not something sort of said off the cuff.
But not prepared for that meeting. Not
prepared for that meeting, but that may reinforce the point. Is that they've prepared something that is available to be shown to potential investors, not merely perhaps in the context of an informal meeting, but in the context of any pitch. Why does the fact that it's late night and informal mean that when you're presented with a document like that, you don't think it means what it says?
Well, that is part of the context. Another part of the context is that the IPD itself was self-evidently an incomplete draft.
As the judge says in his
judgment.
Supplementary judgment. I'm not sure he says it in the judgment.
I think he does say it in his first judgment, but can I come back to that? In fact, I'm pretty sure he does. I may be wrong about that, but can I come back to that, my lords? But he certainly does say it in the supplementary judgment.
Is it page 90 at paragraph 56A?
I'm sorry,
Paragraph 56 of the judgment at subparagraph A.
Thank you.
I don't know, but I'm just wondering if that's what you had in mind.
That seems to fit.
Yes.
Well, it certainly describes some elements in respect of which one can conclude that it's a draft document. Certainly. Thank you. Lord, I'm not submitting, nor do I need to submit, that any other judge faced with the same facts and background, might not have reached a different conclusion. But that's, with respect, I'm clearly on authority, not a matter which this court is concerned with. The question is whether the learned judge was entitled to regard that context in the way that he did, as significant in the way that he did. And there's nothing that you can point to which disentitles him from so doing. The point that is made by my learned friend, as I understand it, is that, well, if you look at the background, paragraph 54 of the judgment, it was clear that there was already debt incurred and that it was intended to try and encourage investment. Well, what does that add? I mean, what my learned friend says is it would be ridiculous not to try and sign somebody up at that time. Well, Mr. Modi may have tried to sign the marks up, but he didn't succeed. And the learned judge found, and this finding is not controversial, that the marks were not committed, were not prepared to commit on the basis of what was said at that meeting, despite their evidence that they were. Evidence that the judge rejected as untrue. And I've shown your lordships the passage in the judgment. In the transcript of evidence, which would explain clearly, in my view, why the learned judge was entitled to find as he did. Next, the other fraudulent statements. Two of them relied upon. Neither of them pleaded.
Do you need to plead points you're going to put to a witness in cross-examination?
No.
No.
But equally, you can't complain if it's not necessarily dealt with in a judgment.
Right.
That's the point. And your lordship and I, in fact, I think, debated the question of similar fact evidence on an appeal. Your lordship may recall a case involving Mr. Sheeran. And your lordship made the point then that similar fact evidence didn't have to be pleaded. And I entirely accept that. But equally, you can't complain if it's not specifically dealt with. My lords, insofar as it just goes to credibility, that takes my learned friend nowhere, because the judge has already made the findings that he has about my client as a witness. And
He wasn't very impressed with his
He was
credibility.
not very impressed, no. Precisely so. He wasn't impressed by anybody, as far as I can see. Well, actually, that's not true. My own client's son and one other
And
witness.
Mr. Carno.
Mr. Carney, yes, indeed. He was impressed by them, but nobody else. My lords, the first misrepresentation, the alleged fraudulent statement, was the one referred to as the honour representation, to which the learned judge refers in passing to paragraph 9 of his supplemental judgment. And your lordships will recall this was about the purchase of franchises. And Mr. Modi said, well, he'd got 11 at 50 million each sold. And what was clear from the transcript of evidence, which is at T4, pages 110 to 112, was that they were committed, but there hadn't been a sale as such. What was not put to Mr. Modi at that time was that when Mr. Modi said what he said in the WhatsApp message, he was acting fraudulently. I've read the transcript and it's just not put. It's not quite right, is it, Mr. Modi? Now, even giving the benefit of the doubt that this was intended to be understatement, you can't come around saying to this court that fraudulent statements were ignored by the judge when you don't even put to Mr. Modi that when he made the statement that he did, he knew it was false. Similarly, in relation to the other misrepresentation, which was, you'll remember, was a presentation made in April 2017, and Mr. Modi referred transcript, day 4, pages 58 and 62, to an event which was said to have occurred by the time of the presentation, but in fact only occurred 2 months later. The learned judge suggested to him that it was wrong, and he accepted that. But again, it wasn't suggested to him that when he said what he'd said in relation to that presentation, he knew that it was wrong when he said it, or otherwise that he was acting fraudulently. In any event, my lords, these are minor matters, and it cannot be that the judge can be criticised for failure expressly to take those points into account when, as I said yesterday, he has stated, and the court should accept, that he had taken into account all the points made, which doubtless included these points in the defendant's closing.
Even if you do prove that a witness has lied on a previous occasion, it doesn't prove that they've lied on the occasion in question.
No.
That's Lucas.
Absolutely.
It's also common sense.
It's also common sense.
Does make it more likely if you show that someone routinely lies to induce investors, then it's more likely they have done on a particular occasion.
I see that, but I think the important point is that it doesn't follow inexorably. My lords, finally, on this part of the case, what are said to be the 2 clear errors of fact. And the first one was by reference to paragraph 82 of the learned judge's judgment. Where he said that Mr. Modi probably did know and approach for Care most, if not all, of the 30 patrons and leaders to whom he may have referred at the April 18 meeting. And my learned friend took you to a transcript on day 4, page 192, which referred to a selection of, I think, 5 of those whom Mr. Modi accepted he did not know, or at least knew indirectly through his son, or likewise. That, in my respectful submission, is not inconsistent with a statement that Mr. Modi probably knew and approached most, if not all, because it wasn't put to him that he didn't know the others. And as a pure matter of mathematics, it was only a small minority who he accepted he didn't know. Secondly, my lords, there were maybe I should take your lordships to that transcript, page 192. That's 192 is a reference to the point I'm coming on to now. Sorry, the identity of those who he accepted he hadn't approached was page 140. I don't think I need to take you to that. But the second point was made by reference to page 192 of the transcript, where the learned friend showed your lordship a passage where the identified individuals, Mr. Modi said, were all proposed. And he said, in answer to the judge's question, most of them had agreed to sit on the board. I don't know whether I had even approached them at that point in time. And, my lords, that was suggested that, therefore, where it was stated in paragraph 82 that Mr. Modi probably had approached those individuals, that was untrue. But that is to ignore the context of that passage in the transcript, which was to do with them being approached as directors, to be directors. You see that at the top of that page. And in 82, the learned judge is not talking about them in the context of directorship, but as being patrons and leaders. Quite different. Secondly, my lord, it was suggested there was no cross-examination on misrepresentations made post-meeting, and that's paragraph 80 of the judgment. Of course, that is a reference to, or the complaint is made by reference to the information memorandum, which we know postdates the meeting by 2 days. And it is a document which the judge deals with in detail at various points in his judgment. I can give you paragraphs 15, 65A, and 72 to 77. And I accept there is cross-examination about it, but where there was cross-examination between pages 131 and 143, or if it must be day 4, day 4, it's quite clear that the judge is involved in that cross-examination and therefore, as it were, all over the issue. Lords, against that background, I think it's important now that I show you the pleaded misrepresentations in relation to the information memorandum. You'll find those in the core bundle behind tab 9. Paragraphs 23 and 24. And you'll see they are paragraph 23 sets out the context, the 3 respects in which those representations were said to be false was 1 about Professor Greco, secondly, and Professor Fuchs, and secondly about Professor Greco, and then 24.3, none of the individuals were directors at any period of time, and none of them had agreed to become a director. Your Lordships may recall from the judgment that the first 2 of those cases were abandoned at trial. So the only continuing representation that was said to be false was about their directorship. But your Lordships, of course, will recall the word proposed, to which the learned judge refers in his judgment, that applied to those directors. And although he doesn't explicitly go on to say that explains that misrepresentation away, he nonetheless does deal with it at paragraph 75 of his judgment. And what he says at the end of that is that their case that they were misled into believing that Sheikh Nayan and others outside the Modi group, including Dr. Shinawatra, had agreed to be appointed later, is evidentially thin at the very least. And so, my lords, it may be that the learned judge did commit an error in failing to refer to the cross-examination on the information memorandum because that was 2 days after the meeting. But there's really nothing in the point, because the outcome of the issue in relation to the information memorandum is dealt with completely by the judge, and nothing turns on that in this appeal. So it's a point that goes nowhere other than to say that even the best judges and the best judgment might make an insignificant and inconsequential error. My Lord, standing back, the overall impression which I suggest that these 7 points create is an attempt, in effect, to snipe away at the edges of the learned judge's judgment. There is no point of real substance being made at all. And the proposition that based on any, or indeed all, of these points, even if well made, the court could say that the judge couldn't reasonably have concluded, as he did in paragraph 89 of his judgment, is in my respectful submission absurd. Certainly it should not be one that is accepted by this court. That's all I wanted to say on the first ground. I can be extremely brief with the second ground, which is the rebuttal of presumption. My Lord Justice Nugee yesterday drew the court's attention to the words "at the time" in paragraph 13 of the supplemental judgment in relation to the word reliance. I entirely confess that I too, like I think my learned friend, had failed to give due regard to those words, and in consequence, in our skeleton, we asserted that the judge had made a finding that the presumption had been rebutted. I unreservedly withdraw that suggestion and accept that no finding was made. Which leaves me with the consequential loss claim.
On ground 2, does it follow that if ground 1 is well founded, then it all has to be remitted? This doesn't provide a separate line of defence.
I'm sorry, Maud, could you start that one again?
Yes. Obviously, if ground 1 fails,
Yes.
the deceit claim fails. Because
That's
you don't have
the end of it.
That's the end of it.
Yes.
If ground 1 succeeds,
Yes.
so there were arguably misrepresentations that needs to go back for trial,
Yes.
the effect of what you've just said on ground 2 is you don't have a separate line of defence.
No, because it wasn't a basis of decision.
Yes. So, subject to what you're coming on to tell us about the consequential loss, on that basis, one would, if one allowed the appeal on ground 1, have to remit it for trial.
Yes, subject only to the point that my lord has made about whether or not one could logically reach a different conclusion.
Yes.
But subject to that point, yes, that is correct. It's what my learned friend seeks, and that's what my learned friend would get if the lordships accept his argument on ground 1. My lords, the particular significance of ground 7 obviously is twofold. Firstly, it doesn't follow that if the court is with my learned friend on ground 1, that necessarily there needs to be a retrial of the consequential loss claim. If the court concludes that the judge was clearly entitled to reach the conclusion that he did on this, that should not be a matter that has to be retried. And that obviously has financial consequences for my client. Secondly, it's relevant in the context of the point with which I started my submissions to my lords yesterday, which is the purpose and proportionality of ordering a retrial if the only issue left is effectively one of costs, with the point that I've made about the likelihood of the extent of any different cost order arising. So against that backdrop, may I start with the central point that my learned friend made, which was to take your lordships to the evidence of his client and effectively forensically say, well, why shouldn't the judge have accepted that at face value? And that was, we'll need to go into this in a little detail, so perhaps we can go to it now. The passage you were shown was in day 2, pages 43 to 45. And I won't repeat them to my lords unless they would find it helpful. one needs to recall, in addition to the points that I'm about to make, what the learned judge has already found about Mrs. Marg as a witness. That in itself must give cause for pause as to whether or not asserted evidence unsupported by documentation is to be accepted. The following points are in addition to that. We stay in the same page and go to earlier passages in the transcript of cross-examination. And my lords, I'm going to ask you to read, I'm afraid it will take a little time, but I make no apology for it because it's relevant. Pages 7, internal pages 7 to line 9, page 13, line 21.
I'll do that.
Thank you. I don't know whether the court has got there, but in effect the position is correctly summarised by the learned judge on page 13 at lines 12 to 20. So despite what the witness had said, the claimant had said, that there were only those 2 investment, in fact, she had got that incorrect, there were 5. And one looks in vain for a reasonable explanation for that. So that doesn't exactly give one confidence in the evidence she's giving in this respect. I then make a small point in passing, but it's nonetheless one which is relevant, by reference to pages 15 and 16. And if you could read page 15, line 7 to 16, line 6, please.
Yeah.
Mr. Price, my learned junior, points out, there is a reason why it's called COVID-19. So that explanation is self-evidently nonsense. Next, at page 18, lines 19 to 25.
So we should look at those.
Yes, just in passing. It's an important piece of the evidence. She accepted that she'd have had to borrow any money to invest in LiveSpace or BitB1T if the opportunity was for 2 million, because she had no available liquidity at that point. Then, my lords, the most important evidence, in my respectful submission, which is at page 40. Perhaps we can pick it up at page 39, line 15, and read through to the bottom of page 40, please. Lords, what follows from that is that she would only have invested 2 million in either LiveSpace or B1T if that was the amount of money she was required to invest in them. And she gave no evidence that that was the case.
In fact, she invested a lesser sum in BIT.
She did. I think 250,000, as I recall. My lords, sorry? It was less than that, was it? Well, you can give me the number, that would be great. Could I just, while we're on that point, remind your lordships of the amendments made to the particulars of Clare in relation to this aspect. Page 128 of tab 9. And my Lord Justice Nugee was right, a lesser amount. In fact, it was only 50,000. One sees from paragraph 34b. So, my lords, just looking at those amendments, the First Amendment, which should not be ignored, is that making quantum a party to this consequential loss claim arose by amendment. It was, until 3 months before trial, her claim, which she then disavowed.
Does that matter?
Well, it goes to the question as to whether quantum would have been the company that would have been used.
But I thought the judge accepted that, or was willing to assume that.
Well, he was willing to assume it in the context of an overall rejection of the claim, but it is relevant. I mean, the judge may have said that's possible, but it's relevant in terms of whether or not the witness's evidence was entirely credible on this point, that she wasn't even making quantum the claimant until 3 months before trial. Maybe the judge should have been tougher on that aspect. He didn't need to be for the reasons that he gave that followed.
Suppose the judge had accepted that she'd been deceived and therefore had incorporated quantum to make the investment, and had accepted that if she hadn't been deceived she would have put 2 million into something else, but not through quantum, through some other entity, would neither quantum nor she have a claim?
Well, quantum wouldn't have the claim.
Would she have a claim?
She might have done, but she disavowed it.
I see.
I mean, maybe that's what they had in mind originally. It's why it was her claim, because she couldn't say that it would have been through quantum. I mean, it's not for me to delve into the interstices of the thinking on the other side of the court. But it's just all of a piece with what I'm suggesting, which is the judge was fully entitled to conclude that this was all far too speculative and not sufficiently proven. Can we look at the other amendments? I don't have anything to say on 34A. Loon, this is 34B, was only able to invest 50,000 because Mrs. Marg had committed all of the remaining liquidity of her family office, being the 2 million, to quantum and to the Iron Care investment. Well, that can't stand. That's completely inconsistent with what she was saying, which is that she effectively was able to have money made available to her by uncles, more than one, when requested. It's completely inconsistent with the pleaded case. (34C) refers to the investment in BIT increasing by a multiple of between 13 and 50. The learned judge's finding was that it was 3.4. No explanation given for that further substantial exaggeration. We also suggested that the basis upon which the court proceeded was an unpleaded basis. But, my lords, before Mrs. Marg gave evidence at trial, there was nothing before the court to suggest that she had needed to nor had borrowed money in order to make that investment. So the cross-examination, which I have shown you, was based on material that was not in her witness statement. And insofar as there was material within her witness statement, it was clearly inaccurate. In those circumstances, my lords, we respectfully suggest that this court should not interfere with the learned judge's judgment on this point. It was clearly a conclusion that he was fully entitled to reach.
So, just to be clear, you accept this point wasn't pleaded?
Yes.
And to be specific, why doesn't that matter?
For the reason I've given. The context is that the reason why it had not been pleaded was because there had not been proper transparency in terms of disclosure or evidence. In the claimant's case, it would be quite wrong for a claimant to leave material part of her evidence on this case to cross-examination and then rely upon that fact in order to be able to say it hasn't been pleaded. I mean, it's absurd. So the context must always be relevant when you consider what might be on its face an unpleaded point. It's a point that was dealt with fully in cross-examination. It was dealt with fully in closing argument. And clearly the fault lies exclusively with the claimant for that being the case.
Mr. Mill, it seems to me at least that as a matter of principle, the fact that a point has not been pleaded could go to one or both of two topics. One is that there may be unfairness in the process at a trial because somebody's not had an adequate opportunity to address a point because they weren't on notice of it. And Mr. Singh made the point yesterday that the pleadings, of course, shape the disclosure exercise.
Yes.
But a second point, as I understand it from the case law, is that because ours is an adversarial system and not an inquisitorial system, that it's not for the court to decide what issues need to be investigated. The parties bring the case before the court and they decide what issues they want the court to decide. I'd be assisted, speaking for myself, on what submissions you make about both of those aspects. Or what in your submission, was there anything wrong with the way the judge approached this, either for reasons of unfairness or because he just strayed beyond what his proper role was?
Well, no unfairness. No unfairness because the claimant should have given disclosure of this because it was highly relevant to her case on causation. And the fault lies fully with the claimant for failing to do that.
Should have given disclosure of what?
No, well,
The loan agreement.
disclosure, I wasn't using disclosure in a documentary
Oh, I
sense.
see.
I was talking about in terms of disclosing the fact
That she'd borrowed the money.
that she'd borrowed the money.
When did you first see the loan agreement?
When did you first see the loan agreement?
Without having been disclosed.
You know, I'm hearing a lot of very important information from Mr. Price, who was, of course, at trial. I think it might be easier, rather than me getting it wrong, if he stands up and just explains what he's just been trying to tell me.
Yes, please. Mr. Price.
My lord, the loan agreement had been disclosed, subject to some redactions, and some correspondence, also redacted, had been disclosed. The pleaded case from the claimant's point of view was that there was a residual regular amount of liquidity in the claimant's family office, which she could choose to invest, and that she did invest. And the what was explored at trial was why it was said that there was a need to borrow money for the iron care investment. And the answer to that was that there was not, in fact, sufficient liquidity in the family office at the time. So that's why we explored the veracity of the other investments she said she had made in the 1 year period that she had defined. And it turned out that in fact there were a number of other investments that she hadn't disclosed. So it was the ability to invest in those that we couldn't explore. It then came out that the lender of the money was a third party, an uncle that we'd not heard about previously. It then turned out that the redactions that had been made in the documents were to redact the identity of the uncle, his relationship to her, and the fact that he had lent the money. And so it became relevant that if he'd lent money when he'd been asked to lend it for or not he in fact would have lent money for these other opportunities, whether he was asked to lend money for the other opportunities, for example, whether there was an ongoing credit agreement. And so all of this was new evidence that came out at trial that was relevant to consequential loss claim. But we had a partial picture, a lot of unanswered questions going into trial, and we tested that against the pleaded case. We got to where we got to. I should just add one point about my Lord Justice Nugee's question about whether or not another company in fact might have invested in Ironcare rather than the claimant. It's an argument that I did run below. It wasn't adopted by the judge because my reading of the judgment is that he found too many uncertainties in any event about whether or not the investment into those other companies would have been made. But he was prepared in principle, so I think court has noticed, to assume that it would have been quantum that would have made the investment. But that's sort of an incoherent point that I think I would seek to revisit.
Yeah, thank you very much. So, Mr. Mill, coming back to my Lord Justice Singh's 2 points.
Yes.
Unfairness. I suppose one way of looking at unfairness is supposing that at some appropriate point you had said, I'd now like permission to amend, and you had amended. Would the Margs have been any better off? Were they prejudiced by the fact that the point had not been pleaded?
Well,
I assume you say they weren't prejudiced.
well, they weren't prejudiced for two. I mean, first of all, the judge would undoubtedly have granted permission, and that would be something which he was entitled to do. Secondly, and in any event, the need to amend, as Maloney Jr. has expressed, has arisen from the timing and circumstances in which that information became available to us.
Can you remind me, because I'm afraid I'm now a bit lost, what is the unpleaded point which you accept was not pleaded?
Perhaps we could just look at the judgment.
Yes.
So it's paragraph 99.
Yes.
And as I understand the way it's advanced by Maloney Friend, it's to be found in the sentence beginning, but among other things, at the top of page 101. It is unclear whether she would have had and used 2 million or any other necessary sum, A, in addition to the Dunbridge loan, or B, as an alternative use of that loan, which restricted other investments, if not for investment in Ironcare, or from other profits or Mr. Marg's salary and bonus, or at all. This seems too speculative to found a sufficient cause. My understanding is, and I don't think I found the point in the pleadings, I'm assuming that's what the Maloney Friend is talking about, is the sentence, it is unclear that she would have had and used 2 million or any other necessary sum in addition to the Dunbridge loan, or as an alternative use of that loan, not for investment in Ironcare. Am I right about that?
Yes, my lord. The point is that the judge rejected the consequential loss claim on the basis that he wasn't satisfied that she may have actually had additional funds available so as to make the alternative investments in any event. So it's what I described, I think, as the additional liquidity point. Whereas her pleaded case and her case throughout was, if I hadn't invested in Ironcare, I would have done X or Y. The judge has now left open the idea that she may have had funds otherwise to make those alternative investments.
But what he's saying is she hasn't made out her case. Her case, we've just been shown her pleaded case by amendment, which is that if she hadn't invested in Ironcare, she would have had extra liquidity to invest. And what he's saying is, well, everything's very speculative. I don't know. I've not found it proved whether she would have had 2 million to invest, whether extra liquidity from Mr. Marg's salary, or whether as an alternative use of the loan, or whether from somewhere else. None of that's been proved, so I reject her case. So what's wrong with that?
Well, with respect, I'll obviously come back to this in reply, but with respect, her case was, had I not invested in Ironcare, I would have invested that 2 million in these alternative investments. And with respect, unless the defendant pleads some case that she would have been able to make those alternative investments in any event, we submit that that's not something that she was required either to give disclosure of or to give or to cover in her witness evidence in chief. So we don't.
Well, I'm now confused because I don't read this sentence as the judge saying the reason her causation case fails is because she could have used other money to make the investment if she wanted to. I just read this sentence as saying, I find it not proved, it's all too speculative, that she would have used 2 million at all.
No, with respect, my lord, that's not a fair reading of this paragraph. What he's saying, in 98 is prepared to proceed, it would have been through quantum. You're absolutely right. In the overall conclusion at the end of 99 is this seems to me too speculative. The question is, what is too speculative? And if one looks at A and C, those are potential sources of additional funding. So I accept B is the alternative use of that loan, and that's the point about whether the loan agreement had a provision in it referring only to iron care. So what he's actually covering in a very unclear way it is two different things. So what he's saying, it's unclear whether she would have had and used $2 million or any other necessary sum, A, in addition to the Dunbridge loan. So what he's saying there is, I don't accept your case on the alternative investments because it's unclear whether you would have had some other money in addition to the 2 million. And her pleaded case and her evidence, so far as she covered this point, was that she would have used the 2 million that was actually advanced for the iron care investment for these other alternative investments. And now the judge is raising the possibility that in fact it's unclear whether she would have had funds in addition to. And then C, my lord, is a point in a similar category or of a similar nature, because the idea there, which is being raised for the first time, is that she might have been able to make these other investments through other profits or Mr. Marg's salary or bonus. And as I say, it was never canvassed that she may have had other funding to make the same investments. That only emerges, Mr. Price has fairly accepted in cross-examination. And just whilst I'm on my feet, Mrs. Marg made completely clear in her first witness statement, paragraph 49, that the iron care investment was made through a loan from her family office. That's agreed supplemental bundle, page 144. So that point was always made clear.
And the answer is it wasn't made available through the family office. It was a bespoke loan from an unidentified uncle. And what Mrs. Marg said was she had only done that using a loan once or twice before. I think that was in one of the passages that I showed, my lord. If it's not, my lord, I can find it. But the key point, which is the point that I identified to my lords a little while ago, is at the bottom of page 40. The only reason why...
Sorry, the bottom of page...
Page 40 of the transcript. It's on page 40, tab 2, page 226.
Yes.
The reason why it was 2 million was because that was what was required for the iron care investment. There was no suggestion, as indeed my Lord Justice Newey observed by his comment about the lower investment, no suggestion that either of the other two possible investments required such a size of investment. So why would she have used that when her normal amount of investment was so much lower? And just as another point, how can you prove a case based on consequential loss when by amendment, having first of all said it's going to be definitely put in one company, you say it might have been put in one company or another? Which of the two is it? How do you decide as a judge what the value of that consequential loss claim is? You have to make a finding as to which of the two it was. You add it all together. This was a completely speculative, unsatisfactory case, and however you parse it, the judge was fully entitled to reach the conclusion that he did. and no reason to suppose that any other judge would reach any other conclusion on the same material second time round.
So just coming back one moment to my lord's points.
Yes.
Unfairness. So it's an unfairness arising out of the fact that the point hadn't been pleaded at some stage. So is it your case that there was no prejudice to the Margs and the fact that the point had not been pleaded?
That is my case.
It's not unusual, if I may say so, Mr. Mill, that points arise during the course of a trial.
Of course.
And they arise during the course of cross-examination of the other party's witness.
And they also arise in closing, sometimes.
Now
The court raises a point
indeed,
with counsel.
And it may be that sometimes fairness requires, for example, that if somebody needs the opportunity
To deal with it.
for an adjournment
Yep.
or to adduce fresh evidence. Was any of that raised at this trial, that we need more time to deal with this point or anything like that?
No.
Right. So
I
do
assume
you
that
say,
was the
do you
case, but
say
I've had confirmation.
fairness, yes, question mark arises in principle on the facts of this case, there was no unfair.
Correct.
Right. And then the second question I raised for your submission
Is
is whether
matters,
the judge can go beyond what the parties have identified as the issues.
but what's happened here is that one party has identified an issue, and once one party identifies an issue, it's an issue. You don't have to have both parties identifying an issue. Unless the court decides that issue is not one that's going to be decided, then once one party has raised it, it's a matter before the court.
And just following on, as you say, the point was in play at least by final submission. It had emerged as something that was being worried about by final submissions.
Yes, as a result of
What had
the
happened in
passages that I've shown
cross-examination. Ms. Dilnot obviously didn't at that point, or did she? I'm forgetting now. Did she object to the point being
you. I
run?
believe she objected, but she didn't ask for more time. I mean, we can look at the transcript. Have we got the transcript?
Well,
of
it's,
her
I think,
objection?
I thought I showed this to you yesterday.
I'm sure you
I
did, Mr.
apologise
Singh,
if
but
I
I'm
didn't.
just forgetting.
No, I think it's both in the transcript, but also her written closing at paragraph 241.
Yes.
But there was also mention of it in the transcript, which I don't have the reference to right now, but I can obviously. But it was fairly insquare. You'll recall there's a paragraph in bold. I think it's in.
Yes.
It's in day 6. No,
But she obviously she objected that it hadn't been pleaded. Yeah. Okay.
Well, there we are. Lords, the only last matter which I was planning to mention, and if only just to put a full stop to it, is the question of the amount of capital to which the interest calculation on a retrial might be applied. And my learned friend, as I understand it, persists in saying it should be on the full 2 million rather than 1 million. But that is not a pleaded case to advance an argument which my learned friend will understand. And in any event, I don't understand it. I mean, that money was made available, but it was presumably being held on interest-bearing deposit somewhere. We don't know that. But I can't see any basis upon which that money should be subject to an interest claim. And I just make the observation in passing that when RPC sent the Without Prejudice Save Us to Costs letter that they did with a calculation of interest, they calculated it on the 1 million, not on the 2 million. Lords, it may be that my learned friend will explain something in reply to which I would like permission to respond on that in order if I understand his case better, but for the moment I don't feel that I can properly assist the court further on.
Thank you very much.
Thank you.
Mr. Singler.
My lords, I'd like to focus in my reply principally on the judge's conclusion in relation to whether the statements were made by Mr Modi at the meeting in the terms alleged by Quantum and Mrs Mark. Now that's obviously the key conclusion, because the issues of reliance and consequential loss don't arise unless those alleged statements were in fact made. Now, what is very important to emphasise, I obviously made this point yesterday, but it is very important to emphasise that because of what the judge says at paragraph 30 of the judgment, and because that paragraph is not the subject of any appeal, if the statements were made, they were false and would have been made knowingly false. And no challenge is brought against that, which makes the present case a rare case, because the issue before your lordships is in fact a narrow one. The court is not being asked to revisit all of the elements of deceit, including complicated questions of falsity and knowledge of falsity and so on. And my lords, what is also important to stress in my submission is that insofar as the case was based upon written representations, the court is well able to read for itself the investor pitch deck and the leadership board. And my lords, what is more, the case is again relatively straightforward in this respect, because only two competing versions or two competing meanings were ever put forward by the parties. So either the investor pitch deck and the leadership board constituted written representations that the relevant individuals had already agreed to participate and assume the relevant roles, or the written statements were, according to Mr Modi, all part of his vision or a wish list, and the idea being that those individuals would be approached in the future. Now, to be clear, in terms of how we frame our challenge to the judge's conclusion, we do challenge the conclusion in a number of different ways. So, first of all, we say the judge failed to give adequate reasons. Secondly, we say there was a demonstrable failure to take account of relevant evidence. And thirdly, we also challenge the substance of the conclusion, and we do say that it was an unreasonable conclusion. And before I develop those points in reply, I do accept, and I accepted this yesterday, but we do understand that the court is naturally reluctant to interfere with appeals relating to factual matters. However, this does take place, and the Symetra case is a good example, also a trial in front of Mr Justice Knowles involving allegations of dishonesty, where the Court of Appeal held that the judge in that case had failed to give proper reasons, failed properly to marshal the issues, and although concision and succinctness are welcome and are virtues, one has to have regard to fairness, and a short judgment has to be a careful judgment, is what the court said in the Symetra case. And in that case, the court said a retrial was an unpalatable prospect, but the greater unfairness would be to let the judgment stand as it was. Now, we've also overnight found another case. So Symetra is a good example of a failure to give reasons, and we've cited that. Overnight, we found the Glencore case, which I hope hard copies of which are on your desks. Now, that case, I don't intend to spend time going through it, but that is an example of this court. It's different. It's not a failure to give reasons. There, the court has overturned the findings of the judge. And in that case, what's significant is that the central factual question, it wasn't a fraud case, it was a contract case, but the ultimate question, the critical question, which the trial judge had to grapple with, was whether a particular statement was made at a meeting, and that there were various contractual consequences if in fact that statement was made. And I'll just perhaps show you a few paragraphs, just so that I can give you the references. I should say I did send a copy of this judgment to my learned friends overnight, and of course if they have anything to say, then but just so that your lordships can see that the shape of this judgment, I don't intend to spend too long because I do accept every case is different, but just to show you that challenges such as the one we are bringing do take place, and the court does overturn findings of fact. One can see, if I just show you briefly what the nature of the arguments being run at 21, you can just see what the appellant's case was. So very similar in terms of the nature of the challenge. And 22, the arguments being made by the respondent, very similar to the arguments we've heard from Mr Mill. And your lordships will see, for example, at 22 Roman 3a, a reference to the McCraddy case upon which the respondent relies heavily here. And then the court in 23 to 25 is absolutely clear that this is only in exceptional circumstances. And you'll see that's regarded as being axiomatic. And at 25, it is with these salutary warnings in mind. And then at 26 Roman 1, you can see the central factual question which I've already described. And I would ask your lordships to read this at leisure, but just again, so you can see the summary of the conclusion. So various errors in the judgment are identified, including by reference to the transcripts. And then one gets the overall conclusion, which I can perhaps jump ahead to. One looks at 73, just so that your lordships can see the heading. So what are the consequences of the judge's errors? And you'll see that at 74, Mr Chowdhury for the respondent was arguing that it was immaterial that the judge had failed to address certain aspects of the evidence, or even if he had made errors and so on. And then the court at 75 and 76 concludes that this is one of those very rare cases where an appeal court is able to say with confidence the judge was plainly wrong, namely as to what the respondent was told at the meeting. So it has some close parallels. And then at 76, you'll see the court says, contrary to the submissions, my reading of the full transcripts. And then I'm well aware that a trial judge has the indubitable advantage of seeing the witnesses and so on. But where a trial judge has clearly gone wrong, and the appellate court has the benefit of the full transcript, this so-called advantage can be overstated. So, my lords, and then if I could just show you 82 and 83, but I would ask your lordship to read the judgment, but 82 and 83, many, if not all of these points, were not, in fact, primary findings of fact, but rather evaluations by the judge of what was said in documents. And then you'll see the overall conclusion at 83. Now, I don't want to overstate the position, because I do accept this is a rare case, but I do urge upon your lordships that this does happen, both in terms of criticisms as regards failure to give reasons, and also as regards challenges on the facts, and particularly where we're relying upon a written representation, and your lordships can see the documents for yourselves. We do say that judgment does have a close parallel. But now if I can turn back to my three grounds of challenge. On failure to give reasons, to remind your lordships, we do say that he plainly failed to give proper reasons. And as I pointed out yesterday, the only findings in the first judgment are to the specific findings, are to the funding representations at paragraph 78. And those funding representations were only ever alleged to be oral representations. So there is in fact nothing in relation to the specific written representations other than a rolled up conclusion on liability at paragraph 89. And we respectfully submit that this is a case where the judge has failed properly to marshal all of the issues, using the words of the court in Symmetra. He failed properly to marshal the factual issues, but my lords, he also failed properly to marshal the legal issues. Because as I say, having set out at paragraph 31 what the elements of deceit are, those indeed were common ground, but he then did, we submit, go on to elide questions such as whether the statements were made and whether there was reliance. And we do respectfully submit that paragraph 87, where the judge in the same paragraph, in a section where he seems to be covering reliance, is also then referring, but only in passing, to the fact that Mr Annan may have been misdescribed in that way at the meeting. And that, we say, is a very clear example of where he's dealing in the same breath with a statement question and a reliance question. And my lords, he's also failed entirely to consider the question of intention to induce. It just doesn't feature at all in either his first or his second judgment. So we do submit he's failed properly to marshal the issues. And when we do get to the supplemental judgment, even at that point, my lords, the judge is saying he does not regard it as necessary to spell out what these representations or what these statements actually did mean, notwithstanding that he's rejected the Margs case. And we respectfully submit that that is an error and that it was incumbent upon the judge, having rejected the claimant's case, to say what, or to make a finding in relation to what these statements did mean. And just on the Kofi Annan WhatsApp, Mr. Mills says, well, yes, that may have been evidence in favour of the claimants, but there was lots of other evidence which the judge relied upon. But just pausing there, with respect, Symmetra tells us at paragraph 46, the fourth point in paragraph 46, is that considerations of fairness require a judge where there is apparently compelling evidence contrary to the conclusion he's about to reach. The judge needs to explain why he's rejecting that evidence. And we do not see any explanation by the judge as to why that message does not support, strongly support, we say, the Margs case as to what statements were made at the meeting. So we do submit this is a case where the judge has properly failed to give reasons. My lords, turning to the second point, the demonstrable failure to take proper account of relevance. Now, I gave various examples just to remind your lordships the most egregious errors, we say. First of all, one looks at the IPD and sees a reference to Dr. Shinawatra in the present tense. He is chairman of Ironcare. Second of all, the Kofi Annan message, he's the board trustee, can only make sense if if the statement was he'd already assumed that position. The third point, which again doesn't feature in the judgment, Mr. Modi gave oral evidence before the judge where he was saying that Sheikh Nayan and Dr. Shinawatra had in fact agreed. So by this stage, my lords, it's absolutely clear what the battle lines are between the parties, the distinction between whether they had agreed or whether they had they were only on the wish list, and that Mr. Modi on oath is saying to the judge they had agreed, and we say the judge has demonstrably failed to consider that relevant evidence. And when your lordships read the Glencore case, you will see in that case too, the judge fell into error because he failed to take into account various pieces of important oral evidence which the relevant witness had given, which contradicted the party's case. My lords, we also say the judge has failed properly to take into account of what has been described as the similar fact evidence. Now, I do understand that those points were not pleaded. We say they weren't required to be pleaded. And I do understand that the judge is not required to make findings or address in his judgment every single point that emerges through the evidence. But my lords, the two examples that I gave you yesterday are so similar, so close to what was actually the subject of the proceedings, that with respect, we do say it was incumbent upon the judge to take that evidence into account. And it's not good enough, we submit, for a judge to cover all matters in a single paragraph, saying, of course, I've taken into account everything. With respect, considerations of fairness require more than that. Where it's a significant point, it needs to be properly considered and dealt with in the judgment. And just to remind your lordships as to why I say these points were so similar, the memorandum sent to investors in April 2017 listed Dr. Shinawatra as a member of the supervisory board. So essentially exactly the same thing going out to investors as was shown and said to the Margs. And the second point about the honour martial arts business, okay, a different business, but it's a false statement being made in writing, not orally as the judge referred to the Margs on the same day as the meeting concluded. So we submit it is remarkable that that sort of highly probative evidence, and it's probative, as Lord Justice Nugee was referring to, on the question of whether it's likely that Mr. Modi would have made false statements at the meeting. That's why we say it was relevant evidence of which account should have been taken. And then we also, my lords, do say there are clear errors in the judgment just on the face of the judgment. So Mr. Mill, again, I gave two examples of this. Mr. Mill has accepted, rightly, that the judge made an error insofar as he says there was no cross-examination of representations after the meeting. That just is simply wrong, because there was in relation to the information memorandum on the 16th of April. And I also referred you to the fact that the judge says, well, Mr Modi knew all or most of these individuals. But my lords, and Mr Mill tries to dismiss that and says, well, most is good enough, I think is really the gist of the submission. But my lords, with respect, that won't do, because what I showed you yesterday was, I think, other than Prince Andrew, Mr Modi said in oral evidence he didn't know any of the patrons. So where the representations are patrons, leaders, and brand ambassador, it transpires, the oral evidence was that he didn't know any of the patrons other than one of them. A fortiori, he couldn't have approached them, or he certainly didn't say that he'd approached them, he just didn't know them. And the brand ambassadors, 2 brand ambassadors were referred to by Mr Modi in his witness statement, Cristiano Ronaldo and Roger Federer, and therefore those were the 2 that featured most prominently at trial. He never suggested in writing, in his written evidence or his oral evidence, that he knew those individuals. So again, we do say that that sort of statement in the judge is just clearly wrong on its face. Now, if I can turn then to the substance of the complaint, so the challenge being the conclusion that the statements were not made in the terms alleged was an unreasonable conclusion. And again, just focusing on the written statements or the written representations. Now, first of all here, we do submit that the judge was wrong to inquire so extensively as to what the documents were intended to convey or what was understood. So there's lots of references in the judgment to what Mr Modi intended to convey and what the Margs understood the meaning to be. But my lords, ultimately, the documents are the documents.
Is that a viable point? When you're dealing with the question of what representations have been made relevantly, you can ask what objectively a reader would have got from the document. But even supposing that a reader would have got from the document that the alleged representation had been made, the claimant still doesn't win if the representor didn't intend that meaning, or if the representee didn't understand that meaning. So those are vital questions, aren't they?
The documents need to be looked at in context, but what the point I made yesterday was that where one has, if I may describe it as a more convoluted type of representation, and in particular an implied representation, there's lots of case law in relation to implied representations where there is a real question as to whether the representor intended to make the representation and whether or not it was subjectively understood in that way. But my lord, here we are dealing, and for the purposes of these submissions, I'm just talking about the documents.
Yep.
And so context is important, my lord, but we do, with respect, say that the judge, in a sense, overcomplicated this question, because, my lord, you look like you're about to ask me something.
At an appropriate moment, I might.
Well, my lord, now is an appropriate moment.
So the documents are, what we're talking about is the document that looked like the investor pitch deck, or something like it.
Yes.
And the what has been called the leadership board.
Yes.
But it doesn't itself call itself the leadership board. I've just been looking at it. I've made the mistake of looking at the colour copy, which may not be identical to the black and white copy. But assuming it's the same, it just says Iron Care Foundation, Mapping the Unknown, and then there's a whole lot of photographs.
My lord,
And what written representation is made by putting a photograph before somebody? It doesn't expressly say anything.
my lord, first of all, that's not quite right, because there is
halfway through, there's a page saying brand ambassadors.
Yes, so that's the first
Yes,
point.
but it doesn't say these people are my vision for brand ambassadors, but it doesn't also say these people have agreed to become brand ambassadors. It is just a series of photographs. Now, the other document, the investor pitch deck, is slightly different because it does say list people as patrons and so on. But I'm dubious as to whether your submission that this is just a simple case of looking at the document is actually a complete analysis of what's happening. This is not somebody just sending a document by email for somebody to read And what do they see on the page? This is a document presented as part of a presentation, and therefore you must colour what the representee understands by a series of photographs by what Mr. Modi says about a series of photographs. And that's why it doesn't seem to me to be just a case of these are the words on the page, that's all you need.
So, my lord, just take that in stages. Only two meanings were proffered, two competing meanings. So these people had already signed up, or these people were on the wish list. That's the first point. So the question is, which of those two meanings is the likely one? My lord, secondly, obviously those two documents were part of the overall pitch. So in a sense, one needs, just again, focusing on the documents, one needs to look at the pack of photos with the investor pitch deck, and it wouldn't be right to look at them independently, as it were. And I was seeking to address you really on the investor pitch deck, because that is the clear example. But my lord, thirdly, it does say brand ambassadors. And we say, if you just look at those two documents together, we say it is, in a sense, common sense that one doesn't just put a pack of photos together with Iron Care on the front and a page saying brand ambassadors and show that alongside something called an investor pitch deck, which is more detailed and has biographies and specific roles attached to these individuals. One is not doing that, we say, simply because that is part of a wish list or a vision. So when I say the documents speak, the submission that the documents speak for themselves is really that as between those two competing meanings, we say it is obvious. I'm coming on to some points about the context of the meeting and so on, which I will address you on. But just, if one's looking just at the documents, we say it would be absurd to put together a pack of photos and saying, I'm going to approach these people. One only does that, we say, and this is the case that was being advanced, because the representor wants the representee to believe these people actually are part of the Iron Care business. Otherwise, it's just nonsensical to refer to them in specific in roles. So, my lord, I take the point about, well, these are just photos, but if one takes Dr. Shinawatra, he's the example I keep coming back to, because the use of the present tense, so it's actually not just a pack of photos, it's something called an investor pitch deck. He is the chairman of Iron Care, and then you get a pack of photos saying Iron Care with the same individuals and a heading or section headed brand ambassadors. One has to really step back and think about the commercial reality with respect, my lord. But can I then turn to the context of the meeting? Because, as I say, we do rely upon the context of the meeting. Iron Care was a failing business at this stage and had debts to pay. Now, Mr. Mill says, well, so what? Where does that take anyone? But, my lords, we say, with respect, that's highly important, because if one is asking, from Mr. Modi's perspective, what meaning was he intending to convey? And if one's asking the question which the judge didn't grapple with at all, was he intending to induce Mrs. Marg? Then it's highly significant, we say, that the context of this was that the business was failing and he needed to raise money. And, as the judge himself found, Mr. Modi instigated the meeting. That is all relevant context, we say.
Just coming back to the first of those points, as you say, the choice is between Mr. Modi representing that the particular individuals had assumed or agreed to assume roles, or on the other hand, that was his vision. Does the fact that there was a need for money really tell you which of those is more likely?
Well, my lord, my primary submission is that this whole question of what he intended to mean has received rather more emphasis than it should have done. But it certainly does come into the analysis at the second stage. If the statement was made, the false statement, was there an intention to induce? I would submit that it is relevant. If one's looking at intention to induce, for example, is he actually trying to raise money at this meeting? And if he's trying to raise money, is he saying to the Margs, I'm going to approach the following people? Or
Well, I follow that, but the judge has knocked you out at a prior stage. Mr. Modi did not intend to convey this meaning.
Yes.
It is not so obvious that the need for money bears on the choice there.
well, with respect, I do submit that it does come in there as well, because if one's asking what meaning is he intending to convey, and one's looking at the two alternative meanings, we say that against the background of him wishing to raise money, knowing that he had these huge debts, the meaning he's intending to convey, we say that the commercial reality is that against that background, the meaning that he's intending to convey is that I've signed these people up. This is a good business. You should invest as part of the friends and family first round. So, my lord, we do submit it comes in at both the intended meaning and also the intention to induce stages of the analysis.
Forgive me, Mr. Singh, if you finish that answer.
Yes, my lord.
There's a slightly different but related point that has been in my mind, as was apparent when I asked the questions of Mr. Mill. If you put the proposition that Mr. Modi was keen to raise money by way of investment in this company, not speaking for myself, that wouldn't come as any surprise to many people. But what you have to go on to establish is that he was doing that with a view to getting commitments at this meeting. Now, the judge said, I think more than once, that he concluded that this meeting that we're talking about was just the start of a process which would inevitably involve greater formality later on. And speaking for myself, I'd be assisted in what submission you make about that point, which I think is a slightly different point from whether it's a vision or not.
Yes. So, my lord, the point I was trying to make yesterday was that the modus operandi, if I can call it that, was to draw in friends and families to invest. That's a phrase that the drawing in technique was used in the oral evidence, and I referred your lordships to that yesterday. And the Marg's evidence at trial was that they essentially, he insisted at the meeting that they commit. Now, a point is made against Mr. Marg because he says, well, I regarded it as a binding contract. Now, of course, a layman's view of whether something's a binding contract or not, we say it's neither here nor there. But their position was clearly that they left the meeting having made the decision to invest. And again, I took you to the messages that were sent the following day where they start to refer immediately to the setting up of a holding company and for the purpose of investing. And I also took you to the emails with Mr. Srinivas, another investor, potential investor in Ironcare, where Mr. Modi was seeking to impose time pressure to get the individual to invest. And my lord, one of the problems we submit with this idea in the judgment, which does feature, I accept it features a number of times, that it was an early preliminary meeting and so on, but with respect, one of the problems with that is that we know the Margs did invest. And the question that the judge never grapples with, and actually on Mr. Modi's case there's been no attempt to grapple with this, why did the Margs invest? What happened beyond the meeting that led them to invest? And so we say actually all of the evidence points to them, to their evidence being correct, that by the time they left the meeting, I think as they described it in their oral evidence, they had decided and committed to investing subject to box ticking. And of course, if something had emerged, they would have stopped at that point, but the decision to invest was made at the meeting.
I'm sorry to rise, but this sounds like yet another ground of appeal, challenging a part of the decision of the judge which had not previously been challenged. That is to say, his finding that they had not committed at the end of the meeting. If it's not what my friend is doing, I don't understand what it is.
No, I didn't understand it that way, Mr. Singler, and correct me if I've misunderstood, because it's important that we should understand your submission correctly. I think that the submission you've just made is that, A, as a matter of fact, there's no dispute that the claimants did in fact make an investment, albeit some months later.
Yes.
B, you say, this may be right or wrong, that it hasn't been suggested that anything happened between the date of this meeting and the date of the investment, which would have induced them to invest, and ergo you see that the reasonable inference then ought to have been that something was said at this meeting which was why they eventually invested.
Correct, my lord.
That's different from saying they were committed to investing at the end of that meeting.
Correct,
is that right?
my lord. I assure you I'm not seeking to introduce a new ground of appeal in my reply submissions on day 2. I'm simply I'm on the point as to the substance of the judge's conclusion in relation to whether the statements made were in the terms alleged or simply a vision. In that respect, or in that connection, I've raised the context of the meeting, and the context of the meeting needs to be looked at from both parties' point of view. What was Mr Modi looking to get out of the meeting? What was the Marg's reaction to the meeting? I mean, that's, in a sense, just a more developed a development of the questions of what meaning was intended to be conveyed and what meaning was understood. It's all part of that question. I'm not seeking to go wider than the grounds of appeal. So, my lords, so just returning to the points, we do say the documents are clear, and the context of the meeting is important, and also the nature of the document. One mustn't lose sight of the fact that it's called an investor pitch deck, and the judge himself, if I could just show you this, which I don't think we've seen before, paragraph 70 of the judgment. As your lordships know,
I'm sorry, which paragraph?
paragraph 70, my lord, I apologise, page 94 of the core bundle. There was a big battle at trial as to whether anything resembling the IPD was shown at all. Mr Modi denied that. And then there was an investigation into different versions. And all I wanted to show you is paragraph 70. The earlier versions of the IPD were used for pitches. So it's all well and good saying, well, some of pages in the slides may be incomplete, but got to be clear as to what this document was. It's a pitch document, and it was used, earlier versions of it in the past were used for pitches. So again, that's highly significant evidence. And then we get to the oral evidence of Mr Modi, where he's telling the court that Sheikh Naihan and Dr Shinawatra had in fact agreed. We have the Kofi Annan WhatsApp message. And then we have the judge's conclusion, where he rejects, this is in his supplemental judgment, but he rejects the illustrative details explanation, but accepts the vision explanation. And with respect, we do still submit, notwithstanding Mr Mill's attempts to defend that reasoning, we submit that that is incoherent, because I showed you the way in which Mr Modi's case was put throughout the litigation, from the defence to his witness statement and to his oral evidence, its common ground. The phrase illustrative details was never used other than in the defence. And we say, therefore, that the judge has created in that paragraph, and we have to remember it's a supplemental judgment, so this frankly ought to have been in the first judgment in the first place, but in that supplemental judgment he has created an artificial distinction between vision and illustrations, and really that wasn't a distinction that arose, because the question, as I keep coming back to, the competing meanings were, have these people signed up, or is this all forward-looking? And one can't then split the forward-looking explanation into illustrative against vision. And my lord, finally, in this context, that the boasts and puffs point, Mr Mill tried to say, well, the boasts and puffs comment is in relation to the vision. But with respect, that doesn't make any sense, because what he earlier tried to submit was the illustrative details were because Mr Modi knew all these people. And so what the judge was saying was these were actual examples. That was the way he tried to defend that part of the supplemental judgment. But my lords, boasts and puffs, well, the statement that I'm going to approach all of these people, that's not a boast or a puff. The only boast or puff that could have taken place was Mr Modi saying these people have signed up. So we do respectfully submit that there's another example of the judge's reasoning being illogical. He's effectively accepting when he says, well, you were gullible, you the Margs were gullible. That only arises, we submit, if the judge on an anterior point has decided that the statements were in fact made. And my lords, for all of those reasons, we say the judgment shouldn't be allowed to stand on whether the representations were made. And indeed, so far as the written representations are concerned, Mr Mill's attack on the credibility of the Margs, we submit, is neither here nor there, because we are talking about the written representations. Now, I understand Lord Justice Nugee's point that one needs to look at everything in the round, but with respect, the written representations are in a different category to the oral representations. And the Glencore case, just to remind your lordships, we say we're actually a fortiori, the Glencore case, because there the issue was whether a particular oral statement had been made at a meeting. The judge concluded no, the Court of Appeal concluded yes. But here, of course, we have, or your lordships have, the benefit, if I can call it that, of the documents. So you can see for yourselves the two key documents. Now, in relation to reliance, Mr. Mill, I think, is now saying he accepts no finding was, in fact, made on reliance. To the extent any finding was made, we would say that also was an unreasonable conclusion, in that the presumption that there was not enough material to rebut the presumption. And then can I come to consequential loss? Because here I just want to be completely clear in the light of the points that arose earlier. The judge was, well, let's first just take it in stages. In terms of what was pleaded, 3 arguments were pleaded. The alternative investments wouldn't have been through quantum. The terms of the loan agreement only permitted investing in iron care and no other business. And I think they put quantum to proof, or the claimants to proof, that they would have invested as much as 2 million in these so a quantum point, if I can call it that. So it was absolutely clear that what was not pleaded was you would have made those alternative investments in any event. Now that's a point that could have been pleaded, but was never pleaded. As a result of it not being pleaded, no disclosure was given on that specific issue, nor would Miss Marg have fairly been able to address that unpleaded issue in her witness statements. I think she produced 3 witness statements before trial, but unsurprisingly, if a point is not on the pleadings, it was neither dealt with by way of reply. So each of the arguments on consequential loss that was pleaded in the defence was responded to in the reply. But the first time this point is really advanced is in cross-examination. I think that is accepted. So it's common ground. This only emerges through the cross-examination. But it's always been clear that this investment was made by way of a loan. As I say, that's clear on the pleadings. That's clear in her first witness statement, paragraph 49.
Well, it says a loan from the family office. It wasn't clear, was it, that it was a loan from somebody else?
Well, let me just show you, my lord. Yes, but
Well, there's a difference between I've got money which is sitting in a family office and I use one of my entities to loan another entity some of what is really my money, and I've borrowed this from an uncle. Those are different statements.
My lord, with respect, the important point for this purpose is that she's referred to a loan throughout.
No, I don't think that is the important point. I think saying I've got money available for perfectly understandable reasons. I use a corporate entity sitting in my family office to make a loan to this particular SPV. It's a quite different assertion from saying I don't have any money of my own to make this investment. I have borrowed 2 million from an uncle. And my understanding is that the latter statement was first made in oral evidence. Is that right?
Well, I believe that is right. The reference to the uncle certainly doesn't appear in paragraph 49 of the first witness statement. But my lord, in any event, the main point here is that even when the reference to the uncle is made for the first time in oral evidence, we say that at that point, if they wanted to advance this as a case for the judge, they needed to apply for permission to amend.
When you say this, I want to be very clear what it is you say. That is the argument that if you could have made this investment anyway, whether or so as a matter of causation, it's not the fact you invested in iron care which meant you didn't make this investment.
Exactly so. So the pleading would say the pleading would say you would have made those other investments in any event. So it's denied.
But it's not at all clear to me that in paragraph 99 of his judgment, the judge accepts that case. That's not how I read the last 2 sentences of paragraph 99. I read them as saying, I'm just left completely unclear. It's not been proved whether any $2 million investment would have been made at all. That's what he's saying.
The reasoning is very compressed. What if I could just look at 99 with your lordship? I mean, you're right, my lord, that obviously the claimant has the burden of proof, but the question is, what does she need to prove? And the issues on the pleadings, what she needed to prove was that but for investing in Iron Care, what she was saying is, I would have used that same money
Yes.
for these alternative investments. And that was the issue. What was never being said was your claim for consequential, no causation, as it were. So even if you were deceived, it's denied that these losses from live space or B1T, it's denied that those losses were caused by the deceit because you would have gone off and made those alternative investments in any event. That's the plea that should have appeared in the defence. And what the judge is saying, and with respect, it's not very well expressed because, as I say, A and C are referring to additional sources of liquidity. And then in B, he's referring to a point which was pleaded and is actually a completely different point because it's an alternative use of the loan. So I fully accept that B was in issue. That was one of the 3 points that does appear in the defence. But what he's saying, my lord, this is a summary of the argument Mr. Price was advancing in closing submissions based on the oral evidence. So we've seen the references in the transcripts, and the judge is taking the point from Mr. Price. And the point that was being run was you haven't proved whether in fact you had additionals, or you've not, as it were, disproved that you wouldn't have had this additional money anyway. That was the case. That was the new case that was being run, and that's what's being alluded to. It's unclear whether she would have had and used 2 million, A, in addition to the Dunbridge loan. So just pausing there. It's unclear whether she would have had 2 million in addition to. Now, how did that point arise? It arose because Mr. Price was saying, well, you had uncles. You've told us in oral evidence you had uncles. So now it's unclear whether, in fact, you had more money than the Dunbridge loan. And C is also reference to the cross-examination, where there was reference to Mr. Marg's salary and bonus and so on. So again, it's unclear whether she would have had 2 million or any other necessary sum from other profits or Mr. Marg's salary and bonus or at all. But neither A nor C arose out of the pleaded issues, because the pleaded issue was simply, would you have invested in the alternative in something else, using the same money that you did in fact borrow for Iron Care? And so, my lord, on this, it's very unclear in 99, but with respect, this is not a point on which the judge was entitled to say, well, you haven't discharged the burden of proof, or this is all too speculative. Because this idea that Mrs. Marg needed to prove that she wouldn't have had any other money, that only emerged for the first time in cross-examination. And with respect, there is a fairness issue. It's fairness, and as Lord Justice Singh said, fairness and whether the judge should be conducting an adversarial or inquisitorial process is clear prejudice, we submit, because, as I say, there would have been disclosure and opportunity to address these matters in evidence in chief. And the point was that the fact that this was not pleaded was drawn to the judge's attention. Let me just show you that one more time. I've got the agreed supplemental bundle. And it's page 238 of the bundle. Your Lordships will see there 241. It's not been treated as a live issue in the case. That's why disclosure has not been given, and why Mrs. Marg did not go into detail in her written evidence.
Yeah.
And I'll just give you the reference, but it was also canvassed in oral argument, closing arguments, at day 6, page 53, line 23, through to page 57, line 6. And my lords, what we've heard from Mr. Mill, which is looking at what Mrs. Marg said in oral evidence, and now saying, well, the claim was hopeless, that is precisely the reason why pleadings are so important, because it's unfair and unjust now to seize upon what she said in oral evidence when it wasn't on the pleadings. If they wanted to advance this case at the end of the trial, then they would have been entitled to make an application for permission to amend, and no such application was ever made. And I think Mr. Mill speculated this morning, well, of course, permission would have been granted. Well, with respect, one can't proceed on that sort of basis. So, my lords, those are my submissions. In terms of the...
Mr. Singler, sorry.
I'm sorry. I'm sorry.
Just if you're moving on to
Yes,
another
my lord.
point, can I just ask you a little bit more about this? As I suggested to Mr. Mill, at least in principle, the fact that something has not been pleaded could go to either or both of 2 points. One is fairness, which you've addressed us on in reply. And then the second is, at least theoretically, what might be called the jurisdiction of the court, because it's not an inquisitorial court, it's an adversarial procedure, and therefore it might be said that the issues are framed for the court by the parties. But Mr. Mill submitted on that second issue that there isn't any jurisdictional problem because the issues were raised by the end of the trial, at least, even if not in a pleading, because the defendant was making this point.
Yes.
Now, obviously, we understand your submissions about the first point, about fairness.
Yes.
But do you disagree with Mr. Mill about the second point?
No, well, it was raised by the end of the trial, but not in a proper way, because it was raised in the sense that Mr. Price stood up and made the argument, but what the submission I'm making is it ought to have been raised, if at all, through an amended pleading.
Well, that's the...
And that's why I see both... Sorry, my lord.
No, I'm sorry to interrupt you. I haven't made myself clear.
No, sorry.
As I understand the authorities, and indeed my Lord Justice Nugee has been the judge in some of those earlier authorities we were shown yesterday, the point that was made in that case law was it's for the parties to identify what they want the court to adjudicate upon. So if the parties have not themselves identified an issue, the court can't for itself. It can encourage them to. It can say, have you thought about this? But it shouldn't, at the end of the day, if they don't agree with the court, that's the end of the matter. Now, what Mr. Mills said about this line of argument was that that's not, on analysis, what happened at this trial, because one of the parties was raising the issue.
Yes.
So it's not that the judge has taken it upon himself voluntarily to go into something the parties don't want him to. And I think that may be said to be a point of distinction from the authorities that you showed us yesterday.
But my lord, with respect, I would treat the two points that you've raised, so the fairness and the adversarial points, with respect, I would treat those as being very closely related and not necessarily in distinct points, because, so you're absolutely right, my lord, that what didn't happen here was the judge didn't think of a point completely, he didn't pluck a point out of thin air and spring that on the parties. He took that from Mr. Price. So in that sense, I think what your lordship's saying is this wasn't the judge conducting a roving inquiry of his own motion. But my lord, we say that's not really a complete answer, because that then takes one straight to the fairness question. And the reason it needs to be pleaded is because of the duty of fairness. And so having raised it, Mr. Price, it was incumbent upon Mr. Price, we say, to make the application for permission to amend. And if it had been raised by Mr. Modi's legal team in such a way as to cause no prejudice, then permission may have been granted. But one can't now speculate as to what might have happened, and we respectfully submit that simply raising a point in an unpleaded way is not sufficient. So my answer, my lord, is that the fairness question and the inquisitorial, the two matters are related. And my lords, I was just going to finish by just dealing with the consequences of where we may end up. So far as the written representations are concerned, we do submit your lordships can decide that for yourselves, but a retrial is inevitable so far as reliance is concerned and consequential loss. And one of the issues in this case is because we formulated our grounds of challenge in the way we have, which is a reasons challenge and a failure to consider demonstrable evidence, those sorts of points normally end up in a retrial. On a question of whether the conclusion is unreasonable, the Glencore case says there are certain cases where the court can decide for itself, but of course we also know there are other cases where retrials are ordered. So my lord, there's a menu of options, as it were, depending on where your lordships end up in the final analysis. And then just very finally, it's a very small point, by way of footnote, just this point about interest, and so the utility of a retrial. First of all, we say consequential loss is the answer to that. Second of all, we say cost judgment. I showed you that yesterday. But a key part of the judge's reasoning on costs was the failure of the deceit claim. So that would need to be looked at again. But the very small point that Mr. Mills says he doesn't understand, the point is simply that, well, there are actually 2 points. So first of all, the 800,000 figure that he refers to, that of course takes into account the repayment, the 200,000 that was ultimately repaid in 2019. But any proper interest calculation, or the argument, I don't think your lordships need to determine this, but the argument goes as this, or would go like this, that what happened was 2 million, the investment, the deceit was inducing an investment of 2 million. 2 million was borrowed, and 1 million of which was invested and 1 million of which was set aside. In relation to the 1 million, interest would run on the 1 million.
Sorry, which 1 million?
Sorry, on the 1 million invested, interest would run on the 1 million until such time as the 200,000 is repaid. So it's not 800,000 from day one, it's 1 million. And then once repayment is made of the 200,000, it would be interest on 800,000. And in relation to the other 1 million, which is never invested, the argument would be it was nonetheless set aside for the purposes of investing in Iron Care. And that is, the argument would be that interest also is payable in respect of that sum, because if interest is awarded by the courts to reflect the loss of use of money, then that 1 million was equally lost, as it were, the use of that 1 million.
This is what I have problems with. If there'd been no, this is on the assumption that the Marks were successfully established, they were deceived into agreeing to this investment. If there'd been no deceit, which is the counterfactual, Quantum wouldn't have borrowed that 2 million. So it wouldn't have had the 2 million sitting waiting for the investment. It wasn't under any liability to Tamares for interest, because the terms on which it was borrowed was that the uncle would get a share of the upside. There was no interest payable in the meantime. So what is...
It's essentially, my lord, I don't want to take up too much time, but essentially it's... obviously, the primary case is I would have invested in something else. So that's what would have happened to the money in the counterfactual. But this is... Yes,
but this is an alternative
Exactly,
case.
exactly. So this is a scenario in which the court for some reason finds that nothing would have happened with the money. Then it's an award of interest to reflect it's the notional loss of use of money, as it were. So if it's
in the counterfactual, there wouldn't have been any money.
Well, my lord, that's the argument. That's the argument. But that's only in relation to the 1 million that's set aside.
Yes.
The 1 million that's invested, the point I'm making is that Mr. Mill says he doesn't understand why it's more than 800,000. And the reason for that is because it is 1 million that's invested, and then only in 2019 that 200,000 is repaid. So on any view, I hope I've...
What's the date from which the interest runs on each 1 million?
Well, I'm not sure a case in relation to this has actually been advanced, but
Right.
I think... yeah, I mean, this, as I say, this.
I mean, I can see that the 1 million that is handed over in November, you want that back with interest from
Yes.
November.
Yes.
But
On the 1 million.
that illustrates that the other 1 million, which wasn't handed over, what is the date from which it runs? Is it when it's borrowed from
Well, the date, in
Tamares?
fact, the date, in fact, the money was set aside was from July 2018. Right. But my lord, that's why this would all have to be argued about. I mean,
Yes,
I do accept that, and that's why I describe it as a footnote to my submissions rather than anything else. My lords, unless I can assist any further, those are my reply submissions.
Thank you very much, Mr. Sigler. Mr. Mill, you must at least be entitled to respond on the new authority.
Yes,
Should you
I agree with that. I'm going to deal, if I may, very briefly with 2 new points raised by my learned friend. And I will be very brief.
Let me break it down. Is there anything you want to say about Elliston and Glencore?
Yes. I should say this is based on reading while my learned friend was on his feet, because I haven't had an opportunity to read it before. But what was very interesting was what my lords were not shown by my learned friend, which is the basis of the challenge. And the basis of the challenge is completely different from the basis of challenge here. If you look at paragraph 28, what is said is that the judge had misunderstood the appellant's case. And at 29, it says in paragraph 15, which I've quoted of, the judge addressed the appellant's pleaded case. I agree with Mr. Craig that the judge's approach to the pleading was not merely over-technical, but was also wrong. And then he gives a number of respects in which that is the case. He says, second, the judge stated there, and he says, paragraph 11, I agree with Mr. Craig's submissions. Both of these statements were wrong and reflected a fundamental misunderstanding by the judge of the appellant's case. It's terribly unsatisfactory to make submissions, in my respectful submission, by reference to background facts and conclusion without looking at the process and the argument that was advanced. Clearly, if a trial judge misunderstands the case, one can quite see why the case will be sent back. How that's meant to help you today, when it's not suggested that this judge misunderstood anything, is beyond me. Secondly, my lords, my learned friend just referred you to a passage in the oral evidence of Mrs. Marg, which was the background to subparagraph C of paragraph 99 of the learned judge's judgment. That's the reference to Mr. Marg's profits and bonus. I just want to show you that passage.
And this is something you're legitimately entitled to say anything about, is it?
Well, it is, because he said for the first time that was the basis upon which the learned judge was referring to. This is going to take 30 seconds.
Yes, all right. Well, Mr. Singler can have the very final word if he wants it, but if it's going to take 30 seconds.
Day 2, page 217, internal page 4. Mr. Price, line 10. I want to start by asking you some questions about how you invest. Your office has a certain amount of liquidity, is that right? Correct. Where does that come from? I believe that's privileged information. But since you ask, I will tell you. My husband's salary, his bonus, and from payouts from the investments we make, the family investments. Can you explain why you say it's privileged information? Because I think the source of my income is personal information. I understand. So the totality of your husband's salary, bonus and payouts is around 2 to 2.5 million a year. Is that right? No, sir. His salary, his bonus and income we receive amounts to an amount that allows us a liquidity of 2.5 million. So I ask you where the liquidity comes from. What's the relationship between the amounts you've just described and what you call the liquidity? Liquidity is the excess capital that is left after running our household. So that was just why I wanted to explain why the judge referred to that in his judgment. And then finally, and I am entitled to deal with this, my learned friend raised as a matter of fact the proposition for the first time in reply that there was nothing before the court which would explain why the circumstances might have changed between April and November, which might have persuaded the Margs to invest.
I'm not entirely sure that's properly the matter of further submissions either, but on the basis Mr. Singler has the last word, then go ahead.
I'm grateful. Would your lordships look at two passages in brief? The first is the amended defence behind tab 10 in the core Bible, and just read to themselves paragraph 10. And then, following on from that, paragraph 92 of the judgment. And 93 as well, but as a matter of generality, 92. In my respectful submission, my learned friend was wrong in his submission in that regard.
In which case, thank you both very much. as you would expect, we're not going to give judgment here and now, but will rather reserve judgment, and as is now the practice, the judgments will be distributed electronically rather than handed down in a courtroom. As you would expect, you will be provided in advance with a draft of the judgment for you to point out our typing and similar mistakes, but not to re-argue the case. I'm sure you're all too well aware of what has been said in the Counsel General for Wales case about the importance of maintaining confidentiality. I know you've provided email addresses for the purposes of sending out the judgment, and obviously we'd stress the need to ensure that dissemination is limited in accordance with the restrictions. In advance of the hand down, we'd be grateful if you would attempt to agree an order dealing with consequential matters. If there are any points on which you disagree, could we please have brief written submissions, and we would expect to deal with those in the order that we make. But thank you both, and those behind you and Mr Price, for a very clear argument.